With the National Association of Realtors settlement and proposed business practice changes, it has never been more important for buyers and tenants to understand the buyer-tenant representation agreement. This agreement has been in our industry since the 1990s when buyer agency came to be, but there was never really a deadline on when we had to give this to a buyer client. Now, with the proposed business practice changes, this legally binding contract will be required to be signed by the buyer and the agent before an agent can show a property. In my last video, we discussed all of the details of the National Association of Realtors lawsuit, settlement, proposed business changes, and the effects that these changes could have on sellers, buyers, and realtors. If you missed that video, be sure to go back and check it out so that you can stay up to date on the facts regarding this settlement and what the possible changes could be to the real estate industry. So I said this in my last video, and I really just want to say it again because it is so important. Buyers, please do not sign this legally binding contract with an agent who has not taken the time to sit down and explain it to you. A big reason why we are in the situation that we're in right now with this settlement is because there was a lack of transparency across the board. This is your opportunity as a buyer to understand the terms of the buyer-tenant representation agreement before you start your home buying process so that you can make sure that you are being properly represented from start to finish. So today, it's not going to be a very sexy video, but we are going to take a look at the buyer-tenant representation agreement and everything that is in it. To be very clear with you, no changes have been made to this agreement yet. This is the exact same buyer-tenant representation agreement that I have given my clients in the past and that I am continuing to use until there have been changes to these forms and we have been made aware of them. I'm sure there will be some changes made to this agreement as well as to the listing agreement if the NAR settlement gets approved by a judge, but either way, this is just great information for a buyer to have. And if we haven't met yet, I'm Stacey Russell, your Northwest Houston realtor, educating buyers, sellers, and investors on all things real estate. If you're not already a part of my community, please make sure that you hit that subscribe button. I would love to have you. And if you get any value out of this video, please do me a favor and hit that like button and don't forget to comment below. I absolutely love answering your questions and better understanding how I can help you. So in a nutshell, the residential buyer-tenant representation agreement is essentially an employment contract between a buyer and a broker. And essentially what it does is allows a real estate professional to exclusively represent a buyer. Once a contract is signed, a buyer goes from a customer to a client. And because of this, there are completely different responsibilities and duties that a realtor has to their client, just like a client has to their realtor. So we'll get to the simple stuff first. Paragraph 1 is the parties. This is where the buyer and the agent's broker will put their contact information. Paragraph 2 is titled appointment, and this is where the buyer is appointing the broker and the real estate agent to exclusively represent them. Paragraph 3 has definitions for acquire, closing, market area, and property. Paragraph 4 outlines the term of the contract or how long this contract is good for. You may decide to have a contract for just one day, but if you've done your research and you have already decided on the realtor that you want to work with, you may decide that you want to work with them for an extended number of days, weeks, or months. So paragraph 5 is a really important paragraph because it lays out the broker's obligations to the buyer or the client. This paragraph states that the broker will use their best efforts to help the buyer in acquiring a property, negotiating the acquisition, and complying with the provisions of this agreement. And paragraph 6 lays out the client's obligations. It says that the client will work exclusively through this particular broker and real estate agent to acquire the property and negotiate the acquisition of the property in the market area that is defined in this agreement. It also says that the buyer will inform other brokers, salespersons, sellers, and landlords with whom the buyer has been in contact with to let them know that they are being exclusively represented by this broker and that agent. And it also states that the buyer will comply with the provisions of this agreement. Paragraph 7 talks about representations, and it has A through E. A says that each person signing this agreement represents that the person has legal capacity and authority to bind the respective party to this agreement. B states that the client is not currently a party to another buyer-tenant representation agreement with another broker. C states that the client represents that all of the information relating to the client's ability to acquire property in the specific market area outlined in this contract is true and correct. D says to name any employer, relocation company, or other entity that will provide benefits to a client acquiring property in that specific market area. And E says that the broker is not authorized to execute any document on or behalf of the client concerning the property. Paragraph 8 talks about intermediary status, and it can get a little bit into the weeds and it's a little bit confusing to understand, but it is something that is important, especially if you're working with an agent who is in a bigger company. As a buyer's agent, I work for the same company as the person who is listing the home. I'm with eXp Realty and my brokerage has over 80,000 agents globally. So it is common for my clients as buyers to want to look at a listing that is listed with eXp Realty. I may not be the listing agent on it, but my brokerage is technically the intermediary. If you check box B, that means that you do not want intermediary status, and that means that you do not want to see any listings that are under my brokerage. Paragraph 9 talks about competing clients, and it basically says that as a buyer, you understand that I may be working with other clients who are interested in making an offer or negotiating to purchase a home that you are interested in. Paragraph 10 is confidential information, and it basically states that during the term of the agreement and even after it ends, confidential information stays confidential. The only two exceptions would be if a client says the information does not need to stay confidential or if it is required by law. Now, paragraph 11 is super important because it talks about broker's fees. And this is one of the biggest changes that is coming out of the NAR lawsuit, because remember, this document right here has to be signed before you ever go see a property in person. Now, buyers and buyer's agents will have to discuss and negotiate a fair price that a buyer will pay in the event that a seller is not willing to do so. A says commission. The parties agree that the broker will receive a commission calculated as follows. So number 1 is a percentage of the gross sales price if the client agrees to purchase a property in the market area outlined in the contract. And number 2 is more for renters. You can either select the first box, which is a percentage of the first month's rent, or you can check the second box that says it's a percentage of all rents to be paid over the term of the lease. Paragraph 11B talks about sources of commission payment. It says that the broker will seek to obtain payment of the commission specified in paragraph 11A from the seller, landlord, or their agents. And in bold and underlined, it says, if such persons refuses or fails to pay the broker the amount specified, client will pay the broker the amount specified less any amounts the broker receives from such person. C talks about earned and payable. It says that a person is not obligated to pay a broker a commission until such time as broker's commission is earned and payable. And then it goes on to define what this means. So a broker's commission is earned when, number 1, the client enters into a contract to buy or lease property in the market area, or 2, the client breaches this agreement. It continues to say that a broker's commission is payable either during the term of this agreement or after it ends upon the earlier of 1, the closing of the transaction to acquire the property, 2, client's breach of this contract to buy or lease a property in the market area, or 3, the client's breach of this agreement. And the last sentence in this section states that if a client ends up buying more than one property under this agreement, that commission is earned and payable on all properties that were purchased by the buyer. Paragraph 11D talks about additional compensation. So in addition to the compensation that is agreed upon in this particular document, there may be a seller or a landlord or a builder who decides that they want to pay an agent additional compensation. This paragraph just says that the buyer's agent is allowed to keep that additional compensation. Paragraph 11E talks about acquisition of broker's listing, and this kind of goes back to what we were talking about with intermediary status. But basically it says that if a client acquires a property that's listed by a broker, the broker will be paid in accordance with the terms of the listing agreement with the owner, and the client will have no obligation to pay the broker. Paragraph 11F says that in addition to the commission specified under paragraph 11A, the broker is entitled to the following fees, and it's got 1, 2, and 3. The first is construction, and it says that if a client uses the broker's services to procure or negotiate the construction of improvements to the property that a client owns or may acquire, client ensures that the broker will receive from a client a fee. So they would list that out there. Number 2 talks about service providers, and it says that if a broker refers a client to a company like a moving company or a cable company or a security company, that basically the broker may receive a fee. It doesn't mean that the buyer has to pay that fee. It's actually a fee that will be paid to the broker as a referral fee, but it's just letting you know that that is something that could happen, and we are being transparent in disclosing that to you. There's also a form that we have to attach it as an addenda to this contract that lets you know all that information as well. And number 3 is other. So if there's anything else where a buyer's agent is going to be getting additional compensation from somebody, we do have to list it out there. Paragraph 11G talks about something called a protection period. And essentially what this is a period of time no later than 10 days after this buyer-tenant representation agreement ends, where I, as the buyer's agent, essentially send you, the buyer, a list of properties that were called to your attention during our agreement. And if you or a relative of yours decides to buy a property that's on that list, it basically says that I can be paid the commission that is outlined in the buyer-tenant representation agreement. It does say that 11G survives termination of this agreement. It also states that paragraph G will not apply if a client is, during the protection period, bound under a representation agreement with another broker who is a member of Texas Realtors at the time the acquisition is negotiated and the other broker is paid a fee for negotiating the transaction. This is really important because even if you sign a buyer-tenant representation agreement with an agent for only 1 day, but you see 5 properties, and then you decide that you want to buy one of those properties that's on that list, you could still be responsible for having to pay your buyer's agent commission to that agent. Paragraph 11H talks about escrow authorization, and essentially what this means is that you are consenting to allowing the title company to disperse funds and all amounts payable to the broker when a transaction is complete. And paragraph 11I talks about county. It says amounts payable to the broker are to be paid in cash in blank county, Texas. Even though I live in Harris County, I always put Travis County, which is actually in Austin and not in Houston, because that's where EXP headquarters is. So paragraphs 12 through 18 really talk about all of the legal stuff pertaining to this agreement. Paragraph 12 talks about mediation. Paragraph 13 talks about default, whether that is on the buyer side or the buyer's agent side. Paragraph 14 talks about the attorney's fees. Paragraph 15 is a limitation of liability, and if you notice, it is in bold. It says that neither broker nor any other broker or their associates is responsible or liable for any person's personal injuries or for any loss or damage to any person's property that is not caused by the broker. It basically also says that you will hold the broker, any other broker, and their associates harmless for such injuries or losses, and that you will indemnify the broker against any claims for injury or damage. Paragraph 16 is titled Addenda, and it's the buyer's agent's responsibility to provide these other documents to the buyer, depending on what kind of home they're looking for. So there are a whole bunch of different addenda. Always, 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 information about brokerage services should be provided. That's actually supposed to be given to you when we start talking about a specific property, because it talks about agency and how you are going to be represented. There's also different addendas for mold remediation, information concerning property insurance, general information to buyers and sellers, protecting your family against lead in your home, which is for any property built before 1978, information about special flood hazard areas. For your protection, get a home inspection, wire fraud warning, and then there's a blank for you to be able to fill out any other addenda that are part of this contract. All right, we're almost there. Last paragraph. Paragraph 18 is additional notices, and once again, this is in bold, so it's important. It says, A, brokers' fees and the sharing of fees between brokers are not fixed, controlled, recommended, suggested, or maintained by the Association of Realtors or any listing services. B, in accordance with fair housing laws in the National Association of Realtors Code of Ethics, brokers' services must be provided without regard to race, color, religion, national origin, sex, disability, familial status, sexual orientation, or gender identity. And there are local ordinances that may provide for additional protected classes. C says that a broker is just a broker. We are not inspectors, pest inspectors, appraisers, surveyors, engineers, environmental assessors, or compliance inspectors. Clients should seek experts to render such services in any acquisition. D says that if a client purchases a property, a client should have an abstract covering the property examined by an attorney of the client's selection or a client should be furnished with or obtain a title policy. E says that clients may purchase a residential service contract, which is a home warranty. The client should review such service contracts or scope of coverage, exclusions, and limitations. The purchase of the residential service contract is optional and not mandatory, and there are several residential service companies that operate in Texas. F says that when viewing a property, a client might be recorded or otherwise monitored without the client's knowledge or consent. I want you to think about Ring doorbell cameras or any kind of security cameras that are inside or outside of a home. Additionally, consult an attorney before recording or photographing a property without the owner's knowledge or consent. And G talks about wire fraud. It says to reduce the risk of wire fraud, clients should refrain from transmitting personal information such as bank account numbers or other financial information via unsecured email or other electronic communication. And at the very bottom where it is bolded and in all caps, it says consult an attorney. The broker cannot give legal advice. This is a legally binding agreement. Read it carefully. If you do not understand the effect of this agreement, consult your attorney before signing. So I know that this was a long video and it had a ton of information in it, and your brain is probably like, what the heck is going on right now? But remember that the reason that I made this video is to make sure that you stay educated on what's going on, and more importantly, stay protected. Because if these changes actually do happen, it means that you are signing this agreement with a real estate agent before you ever go and see a property. And as you've learned from this video, there are some things in this contract that could end up hurting you instead of helping you if you don't select the right agent for the job. Please let me know what questions you have and how I can help you better understand the buyer-tenant representation agreement. As always, thanks for watching, and I'll see you in the next video.